What I came here to share primarily is sort of a very distilled down overview of the basic types of intellectual property, some sort of tips and strategic considerations, and then to reserve the bulk of the time that remains for Q&A. So hopefully I can give you some useful information from that. So without further ado, I'm going to go ahead and share my screen here. And so I have about 18 substantive slides after this, so we should be able to get through it in about, or I should, within about 15 to 20 minutes. And then, at the end, if you'd like to either put questions in the chat as we go along or just do live Q&A, that's great either way. And then some self-evident disclaimers. Obviously, this is for information and education. Keep your secrets confidential, but by all means, if there's something related to issues you're actually facing in a high-level way, feel free to ask. So as most of you probably know, there are 4 basic types of intellectual property, and this is just a very quick summary of the sort of subject matter, if you will, for each of the different categories. And then we'll talk in a little more detail about the scope of protection, term, and then some strategic considerations and some tips that I've learned through 20 years of private practice. Patents cover innovations, devices, compositions of matter, and also methods, although I have the asterisk there because of some of you may be aware that methods are difficult to get these days if they relate to anything that's computer implemented, software especially, if they relate to natural processes or anything else that's deemed to be abstract by Supreme Court precedent or the Patent and Trademark Office. Usually that involves, financial transactions, some business methods, anything that can be done in your head, and so forth. And so in those particular areas, you need to be careful about, the assessment of patentability, but otherwise anything that you can think of under the sun that fits in these other categories, as long as it's new and not obvious, can be patentable. Trademarks, on the other hand, involve source indication protection. Okay, so services or products, you want to make sure that the public's not confused as to who the source is. Copyrights cover the tangible expression of ideas, but not concepts or ideas themselves. And then trade secrets, kind of this wide open category, basically protect information that has economic value by virtue of being kept a secret. And again, we'll go into a little more detail on each of these. So what's a patent? It's a right to exclude, in essence, right? You can keep others from making, using, or selling. It includes importing into certain territories that you have patent protection in. One misconception that comes up sometimes is there's really no such thing as a worldwide patent or an international patent. I mean, there are ways of obtaining international rights in a bunch of different countries through something called the Patent Cooperation Treaty that we'll get to shortly. But suffice it to say that patents are still territorial. Maybe the closest thing that comes to a more universal patent right is being developed in Europe. The unitary patent right there is scheduled to come online sometime, we think, in 2022. And that allows, I think it's 25 members of the European Union to, it allows applicants who are successful in getting a patent to have protection in all those countries without having to do translations and validations on a country by country basis. So that's probably the closest we have to anything that's broader in scope than just specific nations. And you probably also know, but it never hurts to remember that patents don't give you an affirmative right to do anything. What you're doing still can be subject to regulatory authority, can still be subject to infringement, particularly if you are patenting something that's an improvement. You still have to practice the underlying invention. If it has a patent on it, then there could be an infringement issue there. 2 types of patents, utility and design. Utility patents cover pretty much anything that relates to those categories we saw in the first slide. Design, on the other hand, patents cover the ornamental look of something. They have different terms, 20 years from the earliest filing date for your patent application, design patents 15 years from the date of issuance. Patents have to be maintained over time. You pay maintenance fees. Design patents, you don't have to do that. Two flavors of utility patents, provisional, non-provisional. Provisional applications are not really patents, they're just placeholders. So you have up to a year after you file a provisional application to decide if you want to convert it, by filing a non-provisional application. And those are the type that, get examined by the patent office and have some possibility of becoming a patent. But provisional applications are never examined and can never become patents. So first strategy tip when we're talking about patents is it's actually a lot more than a right to exclude. I mean, a patent is property, and like any other property, it has characteristics that make it valuable, such as the ability to be sold or licensed or transferred in other ways. It used to be that you could do a like-kind exchange under the tax code with patents, but I think that got done away with in 2018 with tax reform in Congress. But still, barter or something like that might be a possibility that's not an outright sale, I guess. Otherwise, often you'll see in loan documentation that patents are pledged as collateral, so they can add value there. They can be depreciated or otherwise receive some favorable tax treatment if you donate, etc. Some companies also use patents in their marketing. So unique, it's patent pending is something that you hear every now and then. There's a certain cachet to being patent pending or having patents on products. Sometimes in larger companies especially, patents are used as a reward system. I mean, yes, the company wants to add to its IP portfolio, but they've found that giving a nice little plaque to inventors and a bonus whenever a patent application is accepted and issues into a patent is a nice way to retain employees. And then, of course, in litigation deterrence and negotiation situations, if a company has a nice patent portfolio, it can make it easier to dissuade others from acting against your company's interest, for fear of, they might be sued under one or more of your patents, or, if it's a value proposition, having a large diversified patent portfolio can add a lot of value to that discussion. Here's something that sometimes doesn't get thought of that I saw in practice every now and then, and that is that each inventor on a patent application owns an undivided interest in that patent application, or if it issues into a patent, if there's nothing else in writing that takes care of ownership. And so you can imagine situations here where you want to give an exclusive license, but you never got an assignment of rights from one or more inventors, in which case you can't do that unless you get all of the inventors to assign to, for example, your business entity. So whenever you're talking about third parties, vendors or contractors, but also employees, and any other, strategic partners or collaborators, you definitely want to have a written agreement in place that covers assignment of patent rights. Sometimes you'll see a promise to assign in such documents, and that's very bad. You always have to enforce a promise to assign. It's much better to have present language that actually conveys the assignment and not just a promise. And so in all cases, you want to be thinking about who owns the rights to the patent application of the patent. And of course, if you want to sell or do an exclusive license, it's best if just one entity holds all the rights. Going through the patent application process can be pretty expensive. And so, some tips that, again, these might be self-evident like the first one, but it never hurts to remember when you're dealing with patent counsel that often you qualify for small entity, meaning that you have 500 or fewer employees, or even micro-entity fee status. Undiscounted fees are set at a certain level of the patent office. Small entity is half that, and the micro-entity is half that again. And so it really can add up to some substantial savings. I will say, one little trap to be aware of, and you want to ask counsel or tech launch, whoever you're dealing with, micro-entity fee status, you have to assert that every single time you pay a fee. and their income requirements and so forth, unless you are assigning your rights to an educational institution. And so, something to ask yourself is, if that fee status is ever challenged, do I really want to kind of show years of my tax filings or proof of income to show that I really qualify for that? And it's one of those risk reward situations where maybe you're better off just doing small entity, which is much easier to qualify for, and then you don't get into any of the financial aspects later on. If your patent rights are ever challenged and the other side's looking for a way to invalidate based on, misrepresentation of your fee status. Second tip here is if you have inventions that are related to each other, sort of incremental improvements, et cetera, it can really help to cut costs by rolling a bunch of provisional filings into one non-provisional within a 12-month period. That way, you can decide and prioritize what gets examined and have everything in one filing without filing, 10 separate applications if that's, how many provisionals you have related to particular inventive concept. And then this third one is something that you don't normally think of typically because it costs money or it requires you to do a patent search and then show those results and explain them to the patent office to some degree. But getting an answer sooner on patentability can be leveraged to either not proceed or to decide to file international applications, et cetera. And so if it's a particularly pioneering breakthrough or something that seems like it might have a lot of value, not maybe an incremental improvement, it may make sense to go ahead and pay the money for prioritized examination, for example. And the patent office doesn't guarantee it, but typically, and the data bears this out, they'll get you a first office action and then either allowable claims or a final rejection within about a year. So that's about the time frame, for some people to file international rights. So it can be very handy there. And then, of course, you can file something called the Patent Cooperation Treaty application if you want to defer decisions, where to file later on, and also the cost of filings in other countries outside of, where your first filing is. So let's talk a little more about international patent protection, since that's usually the most expensive aspect of obtaining patent rights. You have the three choices, national applications in each country of interest, regional applications. So I've already mentioned Europe has an existing patent regime under the European Patent Organization. They're working on a unitary patent as well. Africa and Eurasia have a handful of countries that have become a union to have a regional patent in those areas as well. And then there's the Patent Cooperation Treaty, which has by far the most member nations. And again, it allows you to file one application and then, defer the timing of your international filings in individual countries or regions and the cost associated with that until up to 30 months from your first filing date. In the meantime, you get some feedback on patentability, which can really help too, because if you can get some of your claims into allowable or free of the prior art form, it's not a guarantee, but often you can leverage those clean results to get into certain programs like PPH is the Patent Prosecution Highway. And so the US and many other patent offices around the world participate in that program. And that allows users to try to leverage those good results at the international, PCT application level to try to get faster examination and approval in their country or region of interest. So just to give you a graphic of the number of countries that are members of the PCT Patent Cooperation Treaty, you can see that practically all major markets are included. I mean, maybe Argentina and Pakistan and Bangladesh. There's significant textiles in those countries and innovation to some degree in Argentina. So maybe those are notable exceptions, but by and large, most major markets are members. All right, so now let's shift gears. And again, this is highly distilled. And so I'll welcome as many questions as we have time for once I get through all the basics. But trademarks, just remember that their purpose is to absolve or try to minimize customer confusion as to the source of goods or services. Some non-traditional ways that you can obtain trademark protection besides, the common ways of words or logos are product configuration or packaging. The classic example is the old curvilinear Coca-Cola bottle. If you see that at a distance, you don't have to see the word Coca-Cola on it. You just know what that is. Maybe the same thing with Pizza Hut restaurants that you pass on I-10. You see that somewhat distinctive square sombrero red roof, and you don't have to see the sign necessarily. You know what that is. Smells, colors, and sounds can also act as source indicators and therefore become registered trademarks. But those can be hard to get, as you can imagine, because the consuming public has to associate them as a source indicator and not just descriptive, not just a smell, not just a color, etc. So what does a trademark give you? Well, it gives you the rights to use in a particular territory a trademark in conjunction with certain goods or services that you specify in your application for registration. The duration is for 10 years and potentially they last forever. You do have to do some maintenance in the US and a handful of other countries where you periodically have to show that you're still using the mark in commerce by submitting proof of that use. But otherwise, you pay the renewals every 10 years and you're good. Trademarks get their value because of the intangible nature of the association, with goodwill, quality, reputation, kind of those squishy things that people think of when they hear, a particular brand name or see it or smell it. But it won't do you any good unless you police it. And so very often you go to enforce a trademark, and if you've let kind of the marketplace utilize the mark, for competing goods or services, you're going to have a hard time enforcing it, and it really diminishes or dilutes the value of even having trademark rights unless you're on top of them. And one way that you also need to police to make sure that if you're very successful with your products and their brand names is to make sure that they're not being used generically. And you don't have to prevent all generic use. Obviously, you can't control the consuming public en masse. But what you can do is make sure that distributors and retailers get periodic reminders that it's, Kleenex brand tissue or, Coke brand cola and not just, Coke or not just Kleenex. So I listed some famous examples of words that are now common descriptors for their products that you can just imagine, like in the case of the aspirin brand pain reliever, how valuable that might be as a mark these days. But these were all lost to genericide because there was no policing, of retail establishment or consuming public over the proper use, which is as adjectives and not just the names of the goods or services. One thing to keep in mind when we're talking about trademarks is that most other countries do it a little differently than the United States and other common law countries. So sort of all the progeny of the British Empire have these common law regimes where judges can make law, and so you can have common law rights that exist simply by using a mark in commerce. They're not as good as registered rights, but they do give you some rights. In practically all other countries that are civil law in nature, you have to register your rights to have any effect. There can be exceptions for very famous marks, but by and large, if you don't register your mark in these other countries, you might find that that your distributor registers it, and then you might have a problem there, or a competitor, for example. So what are some options for registering your rights abroad? Just like with the Patent Cooperation Treaty, there are some regional trademark applications that you can do, such as the European Union trademark, which gives you rights in all European Union states if you are successful. There's also something called the Madrid Protocol, sometimes or also called the Madrid Agreement, depending on what country you're talking about. But this is basically a long list of member nations that allow you to file one application and then potentially get rights in a bunch of their member countries. Now, which way do you go on this? If you only have a few countries that you're interested in for the foreseeable future, probably individual applications make sense. That'll be more cost effective. Pardon me. Otherwise, if you're interested in, sort of all of Europe or, Asian countries, African countries, South America, it can really make sense to take a look at the member nations of the Madrid Protocol and see if that has the coverage that you need. And then, of course, the European trademark application. I will say that the one thing that I would watch out for, if for whatever reason you want to register a mark that's a little bit high risk, like it's, I don't know, you have very aggressive competitors, and there's some chance that it could be challenged because even though you fought to get it at the United States Patent and Trademark Office, it's kind of a close call. There's some, other similar marks out there. You never know when competitors might try to oppose or cancel your registration, oppose your trademark application or cancel the registration. And so you probably want to avoid the Madrid Protocol in that case too, because there's a feature of that treaty that basically says if the home application or registration dies within 5 years, then all the other applications based on that under the Madrid Protocol also die. It's called central attack, and that, that's a big downside. I mean, you can pay a lot more money and try to get the rights, registered in individual countries after that happens, but just on the front end, you want to be thinking about, is this just a few countries, is it high risk? Maybe, let's keep them all separate and just do individual nations. Some other tips that I've seen over the years, you have to make sure that you file trademark applications in the name of the correct owner. Typically, that's going to be an entity that's producing and or selling, the goods or providing the services, but not always. If there is a situation where, the president of a company files a trademark application in his or her name, and there's no license agreement in place, and it really is the company that is doing everything, that could be a problem. That could invalidate your trademark registration. Also, if you get the entity wrong, I put Gavin LLC on the application, but I'm really Gavin Corporation. Those are different entities. There's no such thing as Gavin LLC. And so I file on the wrong name, that's fatal. I have to reapply because there's no such company that, is the owner of that application. If you have license agreements, you absolutely have to have quality control measures in writing. Otherwise, it's termed naked licensing, and there's lots of sad cases of trademark rights that were abandoned because of a poorly written license agreement that did not have quality control. And then also be careful when you're a startup or you're looking to acquire startups about intent to use trademark applications. There's special provisions under the Trademark Act that apply to intent to use trademark applications with the idea of keeping people from trafficking in trademarks. And so if you buy one of those, you have to make sure you're purchasing all the assets that relate to that. So it could be equipment, recipes, who knows what else, buildings. It just depends. And so those, bear a little bit of extra scrutiny as well. Okay, trade secrets. Something that has economic value by virtue of being kept a secret, pretty wide open. There's no registration or approval process, and potentially the secret can last forever. Maybe that'll be that way for Coca-Cola, who knows? But, on the one hand, it's fairly straightforward to have something be a trade secret. And on the other hand, you have to really think about, what's the best sort of material or subject matter for a trade secret. Certainly anything that can be reverse engineered is not a good category for trade secrets because you can't keep it a secret. And you have to think about patents, for example, or depending on what it is, maybe copyrights, like software, for example. So I list the types of, categories that are best for trade secret protection typically, in areas like software as a service is pretty common now and maybe is better than pursuing patents depending on what you're doing with the patents. Pardon me, it's changing the weather and suddenly now I'm a little congested, but patents that relate to software innovations and computer implemented inventions can be difficult to get unless they really are key to technical improvements, better ways of transmitting data, better ways of accessing or utilizing storage. things like that. So if you look at some of the patent portfolios of even, companies like Uber, for example, you'll see that anything that's been granted recently has some claim language in it that's directed to something technical. It's not just, a method of doing something on a computer. Those are very hard to get these days. And so it may make sense instead to provide those innovations, via software as a service and not even go down the patent road unless, there's something technical that you want to try to lock up. Also keep in mind that to be a trade secret, you have to show, objectively that you're keeping it a secret. And this comes up in litigation all the time. Oh, customer lists, it's a secret, those are sacrosanct, but they were never stamped confidential. They were left out, they were left on the company network. The security was shoddy. You have to show that you're taking reasonable steps to keep it a secret. Otherwise, courts will never enforce your trade secret information. And depending on what it is, reasonable steps might be, having people sign in and give information. It might be security, might be a separate, secure, private network. It just depends on what the nature of the information is that you want to keep secret. Copyrights. So copyrights are suited for areas that involve works of authorship or creation. Those are usually the tangible arts, writings, but also more recently computer programs and graphics. These graphical user interfaces can also be copyrighted, and it protects the tangible expression, not the idea, not the concept. Where you can catch people though sometimes is employee manuals, instruction manuals, websites. People lift that stuff all the time, and if you have a copyright on it, then that gives you some leverage that can actually be quite good leverage, which I'll get to in the next slide. But copyrights last for a good long time. After 1978, so you can see the terms there. Before that, it varied. It can be a little difficult to trace when a copyright expires on something that's older. But if you ever need to do that, the Copyright Office does have some research that, division that can help. So what does a copyright give you? It gives you the right to the exclusive reproduction, preparation of derivative works, including translations, to distribute copies or display, publicly perform the work. Again, only the expression is what's protected, not the subject matter per se, or the function or the idea. Some people don't know that copyrights vest at the moment of creation. You don't actually have to put a copyright notice on, although it's a good idea to give notice so people can't, claim innocent infringement. And you don't have to register, but if you want to sue somebody, you need to register. And also registration can be pretty valuable, because if you register within 90 days of distributing copies, within publication, then you can get statutory damages and attorney's fees if you're ever in an infringement enforcement situation. And so statutory damages basically mean you don't have to prove economic harm. A judge just awards them, in her discretion. And so that could be enormously valuable for leverage, as well as recovering attorney's fees, so your own attorney's fees. So one tip that people should always be aware of is really watch, your website and other uses of stock art or, cheap website or graphic design services. You got to make sure that everything they're using by way of text and pictures or graphics is licensed. So go with reputable, sources, or use your own, if you happen to be decent at photography or graphic design. Because if it's not licensed, you might get a nice little letter from Getty Images or other clearinghouses of copyrights that demand an exorbitant fee in exchange for a retroactive license, or you have to stop and redo everything. Also, similar to patents, you need to have written agreements in place that specifically assign copyrights when you're working with anybody who's not an employee. Okay, so any contractors, for example, somebody writing a software program, or maybe taking a photo shoot of the company members, put on your website, the money you pay for that entitles you to a copy and to use it. It does not entitle you to reproduce it. And those are the copyrights that belong to the copyright owner. And unless they're assigned in writing, guess what? The contractor owns them. And so don't fall into that trap. If it's an employee and the employee is acting within the scope of her employment, then it's a work made for hire, automatically belongs to the company under the Copyright Act. but it's still best to have something in writing, right? In your employment agreement, et cetera, because what if it's a borderline case? What if, the office administrator kind of wears a lot of hats, but they're not really, supposed to be doing photo shoots, et cetera. There might be an argument there that, that they have authorship and need to assign those copyrights specifically. And with that, how we're doing on timing, not too bad, I guess, but hopefully that was not too much too quickly, but I wanted to kind of get through the basics, understand sort of the outline and scope of the IP rights, and then just lay it open to questions, which unless Eric or Anita tell me otherwise, I'll just start reading the chat.